rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Morning, counsel. Let me call the case. Court calls case number CV150318, James Webster versus Winsong Medical Associates and et al. This is time set for oral argument, counsel. I think all of you have been up here before. You know you have 20 minutes for your oral argument. You can set aside 5 minutes as counsel for the appellant for rebuttal. We have read everything. We're very familiar with the issues. And this argument is being uploaded to our website, so be mindful of that. With that, you may proceed.
Good morning, Your Honors. Nice to see everyone. May it please the Court, I'm Scott Boehm, appellate counsel for plaintiff James Webster. Trial counsel Art Lloyd's with me at counsel table. We have three issues in this case. The primary one, I think, is the JMAL on negligence that occurred after September 20, 2010. The kind of tandem issue with that is the jury instructions on it, which I will acknowledge should follow the JMAL ruling. Obviously, if JMAL was appropriate, so were the instructions. And the final one is the manner of death evidence under Gerard, which Gerard, I think, which you only need to reach if I win on the JMAL issue, because that's just a damages issue. I just have a few points. I read over the briefs. That's pretty much my pitch, frankly. I have just a few points I want to make this morning, and then I'll sit down. The first one, and I usually don't spend much, if any, time on this, is the standard of review for JMAL, which was most recently pretty much put to bed by the Supremes in the Glazer case last year, Glazer v. State, the traffic accident case, the highway design, where they clarified it's a summary judgment standard because we're the opponent, the evidence is viewed in our favor. And the only reason I mention that is the answering brief makes what I don't mean to be derogatory, but kind of a left field argument that you should disregard all of our evidence because the court should view the evidence in support of the jury verdict. Well, that makes good sense if you're trying to impeach the jury verdict, but the problem we have in this case for the JMAL is our case didn't get to go to the jury. So it's really inappropriate, and of course all of our evidence was undisputed. We acknowledge there's fact questions on both breach and causation, but for purposes today, our guys, I guess, Dr. Wilson and Dr. Talon, carry the day for purposes of JMAL. Since I'm probably not going to waste all my time, I want to remind the court, I pointed this out in my briefs, but in case you didn't read them carefully, in researching this for the reply brief, there's a minor error in the court's recent, well, it's not so recent, McBride case, which was decided in 2011. This is all discussed in my reply brief, where they misquote the court's earlier opinion in Trustmark on the standard of review that we've just been talking about. In McBride, the court actually says that the evidence is viewed most favorable to upholding the verdict, citing Trustmark, which gets it right. And
maybe we ought to discuss the evidence.
Well, the evidence is pretty much undisputed. And if I don't think you have to look really any further than page 13 of the defendant's answering brief, where they acknowledge that Dr. Wilson, our causation expert, testified that the standard of care required.
Dr. Wilson was the standard of care expert.
Correct.
Not the causation expert.
Right. Although he coincidentally offered causation testimony as well at the end of his standard of care opinions, which I quote. They objected to that on appeal, but they didn't in the trial court. And the significance of his of his causation testimony is it's clearly redundant to what Dr. Talon said about 30 pages later in the February 5th transcript, is that the Coumadin given after the 20th, and especially restarted on the 28th after Betty began to improve, is what caused the left thigh lesion.
Does Dr. Talon did he testify to that?
Dr.
The causation expert, your client's causation expert, did he testify that restarting the Coumadin after the 20th?
Yes. If you want to look at, you don't need to do it right now, I'll do it for you right now, on page 185 of the February 5, 2015 transcript. This is co-trial counsel Mr. Tolman wrapping up his questioning, beginning on line 10 of that page. I think I asked you this question, but I may not have. Do you have an opinion, again, that you can express to a reasonable degree of medical probability if the Coumadin had been stopped on September 20, would the left hip lesion ever have been developed? And then Dr. Talon adds to that question by saying, and wasn't reintroduced, which of course we all agree it was reintroduced on the 28th. And his answer was, no, I don't think it would have developed. So that, 8 lines gets us over JMAL itself. And of course
How does it do that? How does that help you? He testifies that if the Coumadin had been stopped on September 20th and hadn't been given to her again, the last day she got it was on September 20th, the hip lesion wouldn't have developed, and I understand your expert's opinion was the hip lesion is what weakened her condition and
That's correct.
cause of death. So how does that testimony? I mean, he's testifying there that September 20th was the date. That was when the die was cast.
That's the first date. I mean, if you you have to look at the breach, a standard of care testimony.
I'm asking you about the causation expert.
Right.
What else does he say or testify to at trial beyond September 20th, 2010 was the date of causation?
Well, it was if the Coumadin had stopped on September 20, none of this would have happened. She would have lost her breast, but this, as I explained, is not a loss of breast case. This is a death case. The death would not have occurred because the left hip lesion would not have developed if the Coumadin had been stopped on the 20th. But it wasn't stopped on the 20th.
Let me approach it from this direction. Could plaintiff's counsel have stood up in closing argument and said, my causation expert, and this is a limited question, I know, my causation expert testified that if the Coumadin had been stopped on September 21, my client wouldn't have died. Is there evidence in the record where the plaintiff's attorney could have gotten up in his closing argument and cited to the causation expert, Dr. Talon, and stated that?
No, the Coumadin should have stopped on the 20th. But the point of this is that it didn't stop on the 20th. She got more Coumadin on the 21st, the 22nd, the 23rd, the 24th, the 25th, stopped for 2 days, and then it was restarted. This I don't know if this is a good analogy, but it's kind of like if you're a passenger in a car and the driver runs a red light or runs a stop sign, and you break your arm in the ensuing collision. But the driver keeps going, and he runs another stop sign and another stop sign and another stop sign. Eventually, you get killed in another wreck. Their theory is that you can't sue us for all of these stop signs that led to our death because we broke your arm in the first stop sign.
I'm not sure I follow that, but I think the issue is that there's a date by which the Coumadin should have stopped, and any Coumadin that your client received after that, according to your client's expert, whether it was on the 21st, the 28th, any Coumadin after that point was caused her death. So if you were going to save her, you would have had to stop giving it to her by September 20th. That's the testimony. Now, you were alluding to some things that the standard of care expert testified to. So let me approach the question this way. What evidence would the attorney have had, plaintiff's attorney had, to stand up in front of the jury and say, and I also want you to consider what happened after the 20th in terms of causation?
Exactly what I've been talking about. Dr. Talon explained that giving the Coumadin after the 22nd, everyone's thinking about, and apparently I'm not making this clear, that all of a sudden the negligence stopped on the 20th. It didn't. Our standard of care expert, Dr. Wilson, explained in detail, and I go through it in my brief, that it was a breach on the 20th to not stop the Coumadin. It was a breach to not stop the Coumadin on the 23rd. It was a breach to not stop the Coumadin.
In the interest of time, though, let me ask you, because it seems to me, as I interpret the appellee's theory, it's not that there was no evidence of a breach of standard of care post 20th. There was no confluence of causation testimony and breach testimony relating to days after the 20th. Is that your understanding of the theory?
I'm not sure what their theory is.
Okay, well, we'll hear in a moment. But let's say that is their theory. Would you comment on it?
Yes, that's the reason it's wrong, and that's the approach I took in my brief, because the trial court went down the road that once she developed a breast lesion, that's it. I think they agree that's wrong. That wasn't their argument in the trial court. I don't think it's their argument now. She will answer your question, Ms. Dennis. To answer to your question is Dr. Talon's testimony and Dr. Wilson's causation testimony that they didn't object to. When you take those two testimonies in combination, and especially Dr. Talon's, who went on for 13 pages, explaining that the continuing giving of Coumadin after the 20th is what caused this thigh lesion that ultimately caused her death. So I think the thing that I'm not making clear is that the negligence didn't stop on the 20th. They should have stopped the Coumadin on the 20th, but it went on for 5 days, stopped for 2 days, and then started again. All of that is what caused her death. On the 20th, she didn't have a thigh lesion. She had a breast lesion that she wouldn't have died from. Everything that happened after that, Talon explained, and Wilson said in his testimony, that at the end of his standard of care testimony, everything that happened after the 20th is what caused her death. And this, of course, is a wrongful death case. We're not talking about the loss of her breast. They'd take that trade, have their mom back minus one breast, would be an easy trade to make. But that's not this case. Talon was adamant that what happened after the 20th is what caused the death. They don't have, their experts disagree with that. Fine. But telling the jury that everything, that the breaches of the standard of care that were explained by Dr. Wilson and the causation that happened on those post-September 20 breaches are what caused the death, telling the jury to disregard all of that negligence, that was the case. Because what went to the jury, of course we're going to lose this case as it went to the jury. She had a cystin lesion on her right breast, and she was going to lose the breast, but it wasn't going to kill her. That was our evidence. So how are we going to prove wrongful death when our own guy says on the 20th she's not dying? She's dying afterwards, after they keep giving her Coumadin. To get back to my example, they keep running more red lights, or more stop signs. And the stop signs here was stop giving Coumadin. And each subsequent collision after they ran the stop sign is another collision, another dose of Coumadin, 2.5 milligrams a day, which ended up killing her after the 20th. That's what Talon explained very concisely. It's only 15 pages. I'd like to save my 6 if I can.
Yes. All right. Counsel?
Thank
Good morning, Your Honors. Eileen Gilbride for the defendants. With me at counsel table is Steve Bullington, trial counsel. Your Honors are exactly right as to what our theory is. What this appeal comes down to is day 3 of the trial transcript, February 5th, pages 163 to 173 and page 185. I know you've already read those pages carefully. I can tell from your questions. It's the key to the ruling on the judgment as a matter of law. On those pages, Dr. Talon testified exactly this. If Dr. Wang had diagnosed and treated the Coumadin-induced skin necrosis on the 20th, the hip lesion wouldn't have formed. The hip lesion caused her death. So in essence, what he said was Mrs. Webster would have survived if treated differently on September 20th. That's all he said.
Okay. Well, let me let you finish your thought, because I want to talk to you about my understanding of the evidence that's a little different from that theory. But I didn't mean to interrupt you.
Okay. Well, I'm happy to take your question.
Well, okay. Here's the problem as I see it. You have testimony that after the 20th, the administration of Coumadin violated the standard of care. Let's assume for a moment that you don't have any causation testimony about those days, okay?
And we don't.
Okay. All right. So if you're treating each day as a separate claim, then I could well understand how you would grant summary judgment or JMAL on each of those days. But each of those days, it seems to me, is not necessarily a separate claim. The question of breach of the standard of care was on the 20th was a question in dispute. The jury was not instructed that there was a breach of the standard of care. So why wouldn't evidence, even without causation evidence of continued conduct showing that Dr. Wang really didn't get this Coumadin thing, be relevant to the jury's determination whether there was a breach of the standard of care on the 20th?
I think what you're asking me, I kind of got confused by the last part, but I think what you're asking me is if there's standard of care evidence for the 21st and the 22nd and the 23rd, why isn't that enough?
No.
Okay.
Let me tread cautiously
Sorry.
into this stop sign analogy, okay? If I deny running the first stop sign, and there's a dispute of fact on that, but there's evidence I ran 6 stop signs afterwards as well.
Right.
Doesn't that tend to undercut my denial of the first one?
No.
And shouldn't the jury consider it?
No, because if you, and again, I'm not sure that analogy is appropriate,
I
but,
know,
but if you're going to use it, what this case is about is what caused the broken arm. Not did you violate the standard of care, did you run the stop sign, the next one and the next one and the next one. It's what caused the broken arm, and it was the violation of the first stop sign, the going through the first stop sign. Let me go back and try to make this, get at it from a different aspect. Usually, medical malpractice cases are more straightforward in that, say, the person goes in for an easy, routine operation, and the doctor cuts an organ by accident. The causation is there, it's done, and it's done for the next day and the next day and the next day and the next day. It's done then. This case isn't like that because everyone agrees that the giving her the Coumadin was appropriate because she had a pulmonary embolism. She needed the Coumadin to live, to make sure she didn't die from that. So giving it to her was appropriate. The question is, when was the die cast? When was the latest day you could have stopped the Coumadin and she would have survived? The testimony in this case on this record is the 20th. If Dr. Wang had stopped the Coumadin on the 20th, she would have lived. He didn't say, Dr. Talon didn't say, if he had stopped on the 21st, she would have lived. If he had stopped on the 22nd, she would have lived. On the 23rd, 24th, they stopped on the 20th. In his deposition, he said, by the 24th, the die was cast, because the record is also undisputed that When you stop Coumadin, it doesn't just stop, it continues to work in the body. And so there's a point at which the necrosis has already started, and you can't undo necrosis. It just is. And
Okay, but then let's say, forget this is a trial, because we're using the summary judgment standard, right? So let's say that our record shows that if you had stopped on the 20th, there would have been no problem. You didn't stop on the 20th, and there was a problem that was Coumadin-induced. Are you saying that summary judgment should be granted on that record?
yes,
That no reasonable jury could infer that the failure to take that last clear chance gives rise to both negligence and causation?
summary judgment wouldn't have been granted for the 20th, but it would have been granted for the 21st and the 22nd and 23rd, because it was their obligation to come forward with evidence that he did or failed to do something on the 21st, that something that he did or failed to do after that day would have made a difference in her outcome.
It almost seems, though, that that's the inverse of what we should be talking about, because what we're pretty clear on is that administering Coumadin on the 20th didn't hurt her or didn't cause death.
Right.
And the real question is what happened after. That's where the claim
Right,
lies.
and we can't suspect, we can't just speculate on when would stopping the Coumadin have made a difference to her. He says that Dr. Talent says stopping on the 20th would have made a difference to her. We don't know. We're not doctors. We can't just assume, we can't ask the jury to assume that the die wasn't cast or was cast on the 22nd or the 23rd. In his deposition, he certainly said the die was cast already on the 20th. Nothing Dr. Wang could have done would have made a difference on the 24th. She was already going to develop that hip lesion.
So we know that the problem came between the 20th and the 24th.
Well, we know that there was, if he had done something different on the 20th, that's right. If we know that, well, they didn't testify to that. I'm going back to his deposition testimony. The only thing we know based on the evidence in the record before the jury was if he had done something different on the 20th, she would have lived. That's all he said.
By the 24th, there was nothing he could have done.
That's what Dr. Talon said in his deposition. And they didn't go past the 20th at trial at all. I don't know why they didn't, but they didn't. They didn't go past there. And the judge wouldn't let him testify to anything past the 24th because he had already, it was late disclosed and he had changed, it was all set forth in my brief as to why they kind of wangled their opinions to try to have breach and causation overlap because they missed it the first time around. And the judge said, you're not going to testify to anything except what's in your deposition. And what was in his deposition was the die was cast on 24th. But they didn't elicit that testimony at trial. The only testimony they elicited at trial was if you had done something differently on the 20th, then she would have lived. They didn't say if you had stopped the Coumadin on the 21st, she would have lived. And they didn't say if you had stopped the Coumadin on the 21st, the die was cast by then. We don't know. And we are not doctors, and the jury's not doctors. We cannot just have them speculate that if he had stopped the Coumadin on the 25th.
I'm sure doctors know. I mean, all of this is subject to scientific debate.
Well, it is, but they were able to testify to the 20th. They didn't have them testify to the 21st or 22nd. We can't speculate to that. Just because if you had stopped it on, maybe the die was cast on the 21st. Maybe the die was cast on the 22nd, so nothing he would have done differently would have made a difference. We can't speculate about that.
If the die was cast on the 22nd, it would have been cast, though, because he failed to do anything before the 22nd.
But we didn't.
And the 21st lies in between.
But he didn't testify that the die was cast on the 22nd. He didn't testify no one testified whether the die was cast on the 22nd or the 21st. All the jury was left with was if you had done something differently on the 20th, she would have lived. That is all they have. Now, they want to hang their causation case on this little half of a sentence that says, and it wasn't restarted. And they want to use that to make their entire causation case that if the Coumadin wasn't restarted as a, to a reasonable degree of medical probability she would have lived, that's a far cry from an opinion to a reasonable degree of medical probability. All the doctor was doing was clarifying if the Coumadin had been stopped on the 20th, would the outcome have been different? And he said, yes, it would have. The outcome would have been different if Coumadin had stopped on the 20th. He certainly didn't give any opinion to a reasonable degree of medical probability after the 20th. He was prevented from doing that by the court's order.
I don't mean to beat this horse, but back to my original question. We've been talking about causation now for some time. The question whether the administration of Coumadin on the 20th was a breach of the standard of care was still something in dispute, right?
Not the stopping, not the administration, but...
Well, the failure to stop on the 20th
yes.
was not something that was concededly a breach of the standard of care.
Correct.
So to the extent that evidence of the continued administration, which looks progressively worse based on all the testimony in the record, to the extent that could have been considered by the jury, would it not have been relevant to whether sound medical judgment allowed the continuation of Coumadin on the 20th?
That's standard of care.
Right.
We're not arguing about...
But the court didn't allow consideration of the evidence for any purpose, is my understanding. The court didn't make the very fine arguments that we're hearing today. It just said everything after the 20th is out. You can't consider it.
He said that because there was a total absence of causation testimony. It doesn't matter if he breached, and kept giving if it wouldn't have made any difference to the outcome. And we don't know what day that was when it wouldn't have made any difference, and they have the burden of coming forward with that evidence.
But I guess it can give rise to... It could have affected the weight of the evidence on standard of care on the 20th. I agree with you. There may be no evidence of a claim, an independent claim for what happened on a post-20th date. I understand, because you have to have all the elements for a claim.
Right.
But you can have evidence cumulatively affect the weight of an inference for one issue. And if our claim is confined to the 20th and there is standard of care at issue, wouldn't evidence of other related continual breaches of the standard of care be relevant even to that narrowed claim?
That plaintiffs have not argued that the judgment as a matter of law ruling affected the jury's view of the standard of care evidence. If that's what you're getting to, they certainly haven't raised that in the opening brief, or that hasn't been briefed at all. That
is what I'm getting at, and you may be right. It may be waived. But
I personally disagree. I think the judge has to be very careful about being the gatekeeper and only allowing the jury to consider a claim that where there's evidence on all of the elements, the breach and causation and the damages. And there's no causation testimony for any conduct after the 20th. So I think it was completely appropriate for the court to grant the judgment as a matter of law for that reason. If there's no evidence on one of the elements, you have to have judgment as a matter of law. You can't allow the jury to speculate on what would have happened if he had stopped the Coumadin on the 21st or the 22nd, or whether the die was cast or not.
But the instruction to the jury certainly could have been more precise, right? Instead of leaving with the jury with the impression that none of this evidence matters, the court could have said, there's no evidence that anything after the 20th caused her death, and you're to take that into consideration in your deliberations.
I don't think that would have been appropriate at all, because that would have been a comment on the evidence.
Counsel, I'm sorry. So Was the post-September 20th treatment still allowed to be discussed in a closing argument to the extent of telling the rest of the story? In other words, did the court completely strike all that testimony, or just simply as to its bearing on the negligence of Dr. Wang? Was the jury allowed to consider the fact that she did go back in on the 24th and 25th and her condition worsened, that type of thing?
I believe, well, the children did testify as to what happened to her. I don't believe, I don't recall, honestly. I'm sorry to say. I don't want to say if I don't recall correctly. But they certainly argued long and hard about how she, deteriorated afterwards, and how she went to California and she couldn't do this and she couldn't do that, and they had to turn her and debride her and change her diapers, and she was incontinent, and how she stared, and they went into all of what happened to her, inappropriately, I thought, but that has to do with the damages evidence, and I don't know that you want to go into that issue at all. Unless you have any more questions. Anything else?
No, I don't think so.
All right, thank you, Ms. Gilbride.
I have one more comment from trial counsel. The jury did get that information. Dr. Wilson was allowed to testify about the breach of standard of care through the entire treatment through the 28th. And trial counsel knows the record. He remembers it better than I do.
Okay.
Thank you.
But they weren't allowed to consider it. They were instructed not to consider it.
They are instructed not to consider any conduct by Dr. Wang after the 20th, only on the 20th,
Right.
because that's where the causation testimony left. It was on the 20th.
Thanks.
Thank you. Of course, Dr. Wilson was allowed to discuss all of the breaches all the way through the 28th because the JMAL hadn't been granted. He went through that very carefully. And the idea that he never said there was a breach of the standard of care on the 28th is just simply wrong. He went through every day by day.
Was there testimony as to causation on the 28th?
Yes, there was.
Could you cite us to it?
The testimony is that, and I think two things are paramount. One, they never stopped giving Coumadin. If they stopped on the 21st or stopped on the 22nd or stopped on the 23rd, they never stopped until the lesion started. That's the whole point. But more importantly, it is an ongoing tort. If I prescribe some medication to you that you have an adverse reaction to, it's not a on September 20th, it's a tort. September 21st, it's a tort. September 22nd, the whole
Only an actionable tort to the extent that it causes damages.
Correct,
Right?
and it's
So-
undisputed that I'm sorry, Judge, I don't mean to interrupt you. I'm frustrated here. It's undisputed that giving the Coumadin on the 21st, 2nd, 3rd, 4th, 5th, and 28th is what caused the thigh lesion. That's the whole point.
I get the sense that's disputed.
They dispute. Yes, it's disputed. But I mean, what's not disputed is that was our evidence.
I'm looking at the transcript of the standard of care expert. I don't see anything about causation after I see breach of standard of care. Can you show me in this transcript where he talks about causation?
I'm going to have to kind of backwards do it. It was. I'm looking at my opening brief here. It's on pages page 50.
50?
Yeah. And this is the standard of care guy when he mouthed off on causation testimony. On the 28th, the blood is back down to 2, and Dr. Wang started Betty back up on Coumadin. Do you have an opinion as to whether or not that conduct, restarting her on the 28th, met the standard of care? That did not meet the standard of care. And then the next day, the thigh lesion appeared, yes. Do you have an opinion as to what caused the thigh lesion? Probably was objectionable because our standard of care guy is not the causation guy, but there was no objection, and his answer was the Coumadin.
Right, but he doesn't say what date. He doesn't say that the Coumadin on the 28th is what caused the irreversible condition. She already had a thigh lesion by then, didn't she?
No, the thigh lesion came on the 29th, Your Honor.
Okay.
After the Coumadin was restarted on the 28th. But the point is that the aggregate giving of it, we know for a fact, at least for the JMO purposes, that she, as of the 20th, if they would have stopped on the 20th, Betty was probably going to lose most or all of her breast. She was not going to die. They kept giving it for 5 days, stopped for 2, and gave it again on the 28th. The lesion came on the 29th. It's that negligent conduct, and Dr. Wilson said it was a breach all the way along there, and the totality of that ongoing negligence to keep giving Coumadin after it should have stopped is what caused her death.
Where's the best? That's a persuasive way of characterizing it. Where's the best testimony that mirrors the way you just
I think,
said
you know
it?
what, I'm basically parroting my opening brief. In my opening
So we
brief,
should
and you
just
don't have
look
it
to
right there, but if you...
we should just look to the sites there for.
Yeah, and it's a very short site, but I break it up into Wilson's testimony, and then I discuss a few pages of Talon's. And the pages are cited right there, and my guess is they are February 5th, 2015, 172 through 185, and 185 is where he says if they would have stopped on the 20th and not started again and not reintroducing it again on the 28th, she would not have developed the lesion and then died. That's the whole case. That's the entire case. This was not a loss of breast
Take your
case.
stop sign analogy, though. Isn't that a little like saying if you had never left the house and gotten in the car, there wouldn't have been an accident? I mean, at some point, of course, if a course of conduct hadn't occurred, there wouldn't have been harm. But then when you get to the course of conduct that did occur, there isn't specific evidence on the confluence of...
But there is. That's right. Yeah, I guess you're going to just disagree on this. I'm hoping you're being devil's advocate because there absolutely is evidence that the reason she got the thigh lesion that killed her is because she got Coumadin on the 21st through the 25th and again on the 28th. That's what the evidence is. They may not agree with it. The jury may not agree with it. And in fact, the trial judge didn't agree with it.
I thought the evidence was that she got the Coumadin up to and including the 20th, and that's what killed her.
No, Judge, that's completely wrong.
It is.
And I don't mean to be so... that was disrespectful, and I apologize.
It's okay.
That is
disrespectful. You're
that is
quite enthusiastic. But
I am. I guess I take it too
Okay.
personally. That is not even close to what the evidence is. The evidence is that as of the 20th, the Coumadin that she had up to the 20th would have caused her to lose her breast. She would not have died from the loss of the right breast. What killed her is the Coumadin that she got for 5 days after that, stopped for 2 days, and then started again for 1 day. That, and it's very clear, and you obviously haven't had time to read this, or I wouldn't be having to explain this to you. That is what the evidence shows killed her. She would not have died by the 20th. And again, I'm so sorry.
That's all right. Don't worry about it. I don't mind.
I'm out of time. Thank you
Okay.
very much.
All right, counsel. We'll issue a written decision in due course. We're in recess.